did you and I have a talk at your sentencing? It looks like all of my notes are to send you to prison at your sentencing. And I didn't send you to prison. You remember why I didn't send you to prison? Did we have a talk about, are you tired of all this?
I'm tired of all this, and you gotta see something.
Yeah, go ahead. We're on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access to the hearings, both in the courtroom and also online. And we have some probation violation arraignments warrants this afternoon. First up is People of the State of Michigan versus Carly Jean Hurd. It's file 24-6787 FH. Counsel, you want to state your appearances, please?
Mr. Prosecutor, this is Ellie on behalf of Carly Hurd, who joins me at council table to my right.
Okay, and Ms. Hurd, it's alleged that you are in violation of your probation in the following respects. 3 counts. Count 1 alleges that you failed to report to the probation department as instructed on October 14th. And when they attempted to make contact with you, you responded with a text message that you were in Texas and would call when you got back. Count 2 alleges that you failed to complete a substance use assessment as instructed by your supervising agent. And count 3 alleges that you had failed to make payments toward court-assessed fines and costs, with no payments having been posted at that time. Those, at the time that I entered the warrant back on October 16th, those were technical violations that would carry limits on jail, 15 days for 1 violation, 30 days for 2 violations, or 45 days for 3 violations. However, I wanted all parties to be aware that I'm considering that count 1 has ripened into a non-technical violation because absconding from supervision beyond 60 days is not a technical violation. So that means if I find that you failed to report on October 14th and have not reported since then, I could revoke your probation. You are on probation to me for possession of Xanax. That is a 2-year statutory maximum. So do you understand, Ms. Hurd, that if I do find 60 days, I could revoke your probation and sentence you to 2 years in prison? Do you understand that?
No.
All right, so that's the maximum involved. You have the right to have a hearing on those allegations where they would need to be proven by a preponderance of the evidence. And you have the right to the assistance of a lawyer at that hearing. Ms. Elliott's with you here for arraignment. If you request and qualify for publicly appointed counsel, you're entitled to an attorney at public expense. You can present evidence in your defense at any such hearing. You can cross-examine witnesses that are presented, although the rules of evidence don't apply except as to privilege. Do you understand the rights that you have?
Yes, sir.
All right, Ms. Elliott, do you know how she wishes to proceed?
Not guilty, Your Honor.
All right, well, on her plea of not guilty on her behalf, has she requested the appointment of assigned counsel?
Yes, and that'll be Mr. Gilbert going forward.
Okay, and we can schedule this for a probation violation hearing on May 12th at 2:10 in the afternoon. Be assigned to Mr. Gilbert. And as to any pre-hearing release, Ms. Ellen?
Well, Ms. Hurd has been in jail in, Gladwin. When she was picked up in West Branch, they transferred her to Gladwin, just some sort of issue with the West Branch jail. She's been in jail there since January 1st. So she's served that much time. She was able to bond out there.
Wait, she wasn't in jail on this warrant then?
She was picked up on this warrant and there were new charges authorized.
Okay.
And she was held until the other day when she bonded out on the pending charges.
And there was
And
this
then there
hold.
was this hold. So she has been in jail this entire time.
Okay.
So she has a stable place to go live. She, her dad, would pick her up. That, residence was approved prior by the prior agent for her to live. She has a job waiting for her. And she has.
And that would be in what county?
That would be in, down in, Wayne County, where her dad lives. The job is in Canton. She has a plea offer right now on the pending case, to enter into their treatment court. And so she's on bond and under their supervision for that as well.
do the bond conditions for, well, how's
For
she gonna
bond-
enter there? How's she gonna enter, what county's treatment court is she gonna enter?
She would enter, what in West Branch. So
How's she gonna do that if she lives in Wayne County?
They would transfer it down to the Lincoln Park.
So she'd be participating in a treatment court in Wayne County.
Yes, yes.
Do her bond conditions make her, she's not participating in any treatment program as a result of the bond conditions? Is she?
She's required to test for them. She's required to get her substance use assessment in order while she's on bond.
Okay, Ms. Goodrich?
Your Honor, I would ask that that she not be given a bond. We haven't known where she was since almost 6 months. She certainly didn't reach out in the last 4 months while she was incarcerated, and was only brought here because she tried to bond out of that case, and then the warrant was instituted. So I'd ask that bond be revoked until the hearing in May 12th.
Well, Your Honor, it even says when she was arrested for the police report on the pending charges, that she's being picked up on a warrant for Sheboygan County. So she's been in jail, just sitting there waiting for this to be taken care of. And for whatever reason, that didn't happen. So,
Well, I can tell you whatever reason it would be that nobody told us that that's where she was.
yeah. And she, when she was arrested, it's right here in the report. She has an outstanding warrant. She has a bench warrant out of Sheboygan for probation violation.
Right, but that's a
Yeah, I
report
believe-
from which agency?
This is a report from the Sheriff's Department in Ogama County.
Right, okay. So Ogama County knows that she's there
Right.
on our warrant. We don't know that unless
Right.
somebody tells us.
Right,
If somebody had told us, we would have arraigned her on this back in
Yeah.
January.
yeah.
Okay, well, what's the offense date on the new charge that she has?
January 1st, that's when she
Yeah,
was.
so she's picking up new charges while she's on probation as well.
Well, and Your Honor, there's an active investigation in regards to the background of those charges. And so I think her disposition on the pending charges is because of the investigation that they're doing on what was surrounding the fact that when she was arrested on that.
You feel, I mean, I guess the charges are public record. What's the charge that she picked up on January 1st?
It's a possession charge.
Of what? Possession of?
That means tenure.
I mean, I know we've only got her here on a 2-year, but you know, she just kind of checks out from supervision, tells the agent, well, I'm out of state. I don't know if she had permission to be out of state or not. I'm out of state. I'll call you when I get back, and nothing happens. And she picks up another felony. I guess I don't have a high degree of confidence that she's going to cooperate with what's going on here on this petition. So I'll order her to be held without release pending further order of the court. The hearing's only a couple days outside of the 14-day window. So May 12th at 2:10 p.m. We'll see you then. All right, and then we'll next call people of the state of Michigan versus Felicia May Carney. It's file 25-6977FH. That's prosecuting attorney Ms. Goodrich for the people and Ms. Elliott for the defense for arraignment. And Ms. Carney, it's alleged that you're in violation of your probation in several respects. Let's see, count 1 alleges a non-technical violation that you engaged in new criminal behavior on April 4th and were arrested by the Grand Traverse County Sheriff for a misdemeanor assault. Counts 2 through 5 allege non-technical violation, or I'm sorry, alleged technical probation violations. Count 2 alleges that you were arrested for that simple assault on April 4th. And the sheriff's report indicates that you appeared to be extremely intoxicated and incoherent, and you had a PBT at 0.251. So it's a violation of special condition not to use or possess alcohol.
Yeah.
Count 3 alleges that you failed to report to the probation department as instructed on April 6th. And since that time did not have contact with a supervising agent by phone or in person. And as of April 15th, your supervising agent did not know where you were. Count 4 alleges that you engaged in new criminal behavior by being arrested for simple assault, and that constitutes assaultive behavior. Count 5 alleges that you failed to contact the probation department within 24 hours of your police contact or arrest, and that's also a condition of your probation. So If you are found to be in violation, it looks like we've got a couple previous technical violations as well. So if you are found to be in violation for the criminal conduct of the assault, I could revoke your probation. If you're found to be in violation.
No, I didn't do it.
Well, hang on, don't do that. Your attorney wants you to just follow the process so that we protect all your rights, okay? And if you're found to be in violation on any of those technical matters, there are some limits to the jail you can receive. You've already got a couple prior ones, so I think we'd already be at the 45-day. Or if we're at the 4th or beyond, then we could revoke your probation. So really, the maximum penalty you're facing here is revoking your probation. And you're on probation to me for a charge of possession of methamphetamine. That's a felony. It is punishable by a maximum of 10 years in prison. So do you understand the maximum here in this case?
Yeah, I did.
All right. Now you've got the right to have a hearing, Ms. Carney, where the prosecutor would need to prove these violations by a preponderance of the evidence. You have the right to a lawyer, including a lawyer at public expense if you request and qualify. You can present evidence at any such hearing and cross-examine the witnesses presented against you, although the rules of evidence don't apply except as to any privilege, like between you and your attorney. Do you understand the rights that you have?
Yes.
All right, and Ms. Elliott, you know how she wishes to proceed?
Not guilty, Your Honor.
Okay, will her plea if not guilty on her behalf, has she requested signed counsel?
Yes, and that'll be Mr. Nightingale.
Schedule this for probation violation hearing on May 12th at 10:30 a.m. And do you know the status of any charge in Grand Traverse County on that misdemeanor assault?
I do not. I do not.
You arraigned on that, Ms. Burns?
No, I didn't even see a judge. I went, like, I got the assault or whatever. I did do it. I moved to Traverse City to get my stuff. I got a job there. Got it established, stupid.
All right, well, I'm gonna cut you off there. I just wanted to know the status.
No,
of the
I
case.
didn't.
Okay, all right. All right, again, I don't want you to tell me about what happened in the incident. I just wanted to know about the status of the case procedurally.
No, I
Okay.
didn't.
Okay. As to release between now and the hearing, Ms. Elliott?
Well, Your Honor, Miss Carney has a place to live at the Safe Harbor in Traverse City. She secured employment at the McDonald's there. She's gotten approval from NEMSCA for some rental assistance so that when she finds a place, she can move out of Safe Harbor and into her own apartment. So she's really trying to, get things started over and get herself in a stable environment. So we'd ask for a bond to allow her to continue on that path. Thank you.
Okay, Ms. Goodrich?
Your Honor, the concern here is obviously the drinking while being on felony probation for possession of methamphetamine, but this is her second criminal case that she was charged with. The previous one was a MDOP. The concern here is they both involve victims. So while we have her out in the community, other people are suffering as a result. I realize they're both 93-day misdemeanors, but I think that's important to consider. Thank you.
All right, well, here, we don't have a whole lot of, we haven't been making a whole lot of progress with Ms. Kearney on probation, but if she's got, what is Safe Harbor in Traverse City?
It's a homeless shelter for right now. I moved there to get a job. Start over in new because I wasn't doing very good. I was doing excellent on my probation and I am doing good besides the few times I've tried, yes, some stupid decisions.
How would you get back over to Traverse City?
I would have to take a bus today. I would see if maybe like somebody could pay for Indian Trails. All my stuff is there.
And Safe Harbor, you've got a spot there still?
Yes.
What about this job? Have you started that?
No, I was supposed to, but I probably lost it. I'd have to call them and, you know what I mean? Refigure something out.
When were you supposed to have started it?
2 days ago. I've been in, or the day I went into Traverse City, or they picked me up for the warrant.
If we were to call the McDonald's in Traverse City, or, is this true? I can't tell you.
It
how many-
honestly is true, but I haven't started it yet, so I'm telling you, I was supposed to have a position there, yes, I have not started it, I was picked up on the warrant.
It's amazing. I maybe people should not be so keen to find a job because I can't tell you how many people get arrested like the day before they're supposed to start a job.
I understand that.
So it's hard for me to believe.
I totally understand, I really do. But there's no reason for me to lie to you. I'm telling you, I did do the assault, it was stupid.
Well, your lawyer really wants you to stop saying that, all right. My my hemming and hawing here is I'd really like to see Ms. Carney get some traction toward some kind of housing and employment plan moving forward. But it sounds like, you know, what she's got in place sounds a little bit shy of an actual, you know, tangible plan. This is the second criminal alleged violation since she's been on probation. The case is a borderline prison case to begin with. It was pled down to possession of meth, but this was a very serious possession with intent case for which her co-defendant went to prison. And she's been kind of on that bubble and, you know, not responding to the probation agent, being arrested at a 2-5 and being assaultive in the community. I guess I'm hesitant to derail any progress that she's been making, but it sounds like that was minimal progress at best. So I'll order her to be held without release until further order of the court. The next hearing will be the probation violation hearing on May 12th at 10:30. All right, our third and final arraignment on a warrant here is People of the State of Michigan versus Austin David Noble, file 25-6985 FH. We've got Ms. Goodrich for the people and Ms. Elliott for the defense. All right, Mr. Noble. It's alleged that you're in violation of your probation in several respects. Count one alleges that on or about March 22nd, you were in possession of a controlled substance methamphetamine. Count two, same date, you used a controlled substance methamphetamine. Count three, same date, you were in possession of drug paraphernalia, glass methamphetamine pipe. Count four, on or about April 21, you were in possession of marijuana. Count five, on or about the same date, you were in possession of drug paraphernalia, glass marijuana pipe. Count six, on or about the same date, you're in possession of marijuana without having a valid medical marijuana card. Count seven, those are all technical violations. The counts 1 through 6. One technical violation has a maximum 15 days jail. Two has a 30-day maximum. Three has a 45-day maximum. 4 or more, I could revoke your probation. There's also some non-technical probation violations, and those are the same factual contact, but they allege that you violated the law. Count 7, on or about March 22nd, you violated criminal law by being in possession of methamphetamine. Count 8, same date, you violated criminal law by using a controlled substance methamphetamine. Count 9, on or about April 21, you violated criminal law by being in possession of marijuana. Those are non-technical violations. If you were found to be in violation on any of those, I could revoke your probation. So you are on probation to me for possession of methamphetamine as a habitual offender second. That carries a maximum of 15 years in prison. So the maximum penalty that you could face on these allegations of violation of probation would be revoking your probation, sending you to prison with a 15-year maximum. Do you understand that? Right. Now you've got the right to have a hearing on these allegations of violations. You've got the right to have a lawyer, and if you requested and qualified, a lawyer at public expense. You have the right to present evidence in defense at that hearing and to question any of the witnesses presented against you, although the rules of evidence don't apply except as to privilege. Do you understand the rights that you have? Right, Ms. Elliott, do you know how I wish to proceed?
Not guilty, Your Honor.
You want her plea of not guilty on your behalf as to those charges. Has he requested assigned counsel?
Yes, and that'll be Mr. Nightingale going forward.
All right, we'll schedule this for a probation violation hearing on May 12th at 10:40 a.m. And Mr. Noble, when were you released from the jail on these charges? On my case that I sentenced you for back in, when did I sentence you? Okay. And then you were-
August 11th, service over 9 months,
And then you were going to go down to KPAC
and I went to Cape Cod for 3 months.
and you
Townsend.
didn't finish it.
I finished everything, but it kicked me out a week early, but all my books, everything was done.
I mean, you've signed an acknowledgement back in August for a violation for failing to successfully complete KPEP.
I did not know that.
Well, your signature's right on it.
Yes, sir, I don't understand that. I think that's what it was forward, so it's my fault.
Okay. Did you and I have a talk at your sentencing? It looks like all of my notes are to send you to prison at your sentencing, and I didn't send you to prison. Do you remember why I didn't send you to prison? Did we have a talk about, are you tired of all this?
I'm terrible, so you gotta see something in me.
Yeah,
This is my first.
So what happened?
relapse, and I'm thinking about- They say in recovery report or whatever, like, you're
Yeah.
supposed to relapse, but I'm possibly going to prison for relapse.
yeah. You're not supposed to relapse and recover. Whoever told you that is wrong. All right, all right. As to any pretrial release or pre-hearing release, Ms. Elliott?
Well, the bond was set yesterday in district court. The new charge is at 75,000 cash or surety for the full bail, which Mr. Noble is not able to post. He does have a full-time job working at the Dixie. He also has part-time work with his dad doing handyman work. He was just promoted at the Dixie. You know, he has a living environment with his mom and his stepdad. You know, we'd be asking for a bond that he's able to post, perhaps even a PR bond, so that he can work on maybe posting the bond in district court so he can get back out and get back to work.
Your Honor, the court is very familiar with Mr. Noble in the last 4 or 5 years. At this time, he's on felony probation for possession of meth. He's found with methamphetamine and also with marijuana. I would ask that no bond be set.
Do you know, so the new charge, is that a Sheboygan County charge?
It is.
Do you know the quantity or the circumstances of that that's alleged? Or
It was in a pipe.
it was a traffic stop?
Yes.
Okay. All right, well, for now, Mr. Noble, I'm gonna have you held without bond till the May 12th at 10:40 a.m. till further order of the court. I don't know what else you've been up to. But you know, and there's no guarantees, but the only way I'd consider a release for you is if it's to some kind of treatment facility.
All right,
And there's no promise that I would approve that, just I would want to see that that's the plan. But otherwise, I don't know how this is going to shake out. I mean, I probably should have sent you to prison back last May, so I don't know how this is going to shake out, but that is definitely a possibility you need to be starting to think about.
Sure.
Okay. All right, we'll see you on May 12th,
Judge, what was the time for that? hearing?
10:40 a.m.
Thank you.
Okay, that'll conclude our docket this afternoon.
If you enjoy real courtroom drama and shocking sovereign citizen moments, make sure to subscribe, hit like, and turn on notifications so you never miss the next courtroom showdown.